Welcome back to another edition of Chicago's Legal Latte. Hi, everyone. I'm Jim Mitchell, and as always, pleased to welcome to this podcast today two members of Lavelle Law. Representing the firm today are Ted McGinn, managing partner of Lavelle Law. Ted's been with us a number of times in the past, and Eso Akunne, an associate. And Eso and I spoke not too long ago about med spas in Illinois. I'm going to dive a little bit deeper into that today as we find out some of the things happening in the state and restrictions and rules that people should understand before they open up a med. Both of you, thanks for being here today. Really good to talk to you both again.
Thanks, Jim, for having me. Always good to be here.
Likewise. Thank you, Jim. Looking forward to it.
So I always like to start with the formal tech, the formal wording. We're talking today about the corporate practice of medicine doctrine. We're going to dive into that, but one of you kind of take me through what that means in the use case we're talking about today.
Yeah, I'll jump in and tackle that. So the corporate practice of medicine is an interesting doctrine. It's been around for many, many years. And in a nutshell, what it means is that only physicians are able to practice medicine. And if they want to use a corporation, that's fine, but it has to be the owners also have to be licensed under the state of Illinois to provide physician services. So that would include medical doctors, of course, doctors of osteopathy, and doctors of chiropractic as well. All those three would be the types of individuals that can own an interest in a corporation that practices medicine.
So maybe kind of recap for us some of the things we've talked about in the past, and Ted was alluding to it. Obviously, if you are a physician or practicing medicine in some way, you still are running a business. So when we look at this particular topic now, what does that entail? I mean, does a doctor who wants to open a practice set up a corporation or an LLC or some business entity to be in practice?
Yes. So they would set up, like you said, an LLC or a corporation, and you would have to work with the IDFPR in making sure that your business license as a medical spa is approved by them. And just to add into that corporate practice of medicine, the methodology behind it is just to make sure that non-physicians aren't able to have that aren't able to bring their judgment in terms in reference to helping patient care. They want to keep medical professions as the ones who make the determination on how patients get their care. That's just a kind of an overview of why the corporate practice of medicine doctrine is how it is.
Yeah. The concern is that profit motive may interfere with judgment and decision making, and so they think that would be there if you had non-physicians who were part of the ownership structure of the entity. So that's where the concern is, and as Eso said, that's why they limit who can be an owner of a corporation or LLC that's practicing medicine.
And we've seen private equity invest in just about anything you can think of. Reading about them potentially investing in college athletic teams now. So is this the kind of thing where we're talking about people who are seeing a particular profit center just saying, look, this is not where you belong. You can't have outside investment?
Yeah, exactly. And interesting enough, different states have different types of these sort of corporate practice of medicine statutes. Some states are more strict than others. Illinois kind of fits kind of in the middle zone of strictness. Other states are more open, and you may have more private equity ownership in some of these practices. But basically, that's where the background is, and that's the concern. And as a result, when we started looking at these companies, these businesses, we have to evaluate this to see if there is a corporate practice of medicine issue that we've got to be worried about.
In preparing, we talked a little bit about another term here called fee splitting, and something that is prohibited in Illinois. Can you kind of define that for us as well?
Yeah, you get into fee splitting. Again, the concept there is a physician is not permitted to split a fee that is generated or earned for the provision of physician services. And And where that gets into play is when you have certain sort of, independent contractor arrangements or other arrangements where a fee that's being paid to a non-physician is determined in a certain way. I mean, a percentage sort of fee is really what brings that fee splitting into play.
And so when we talk about this new evolution of med spas, where there may be a physician or a chiropractor, but there may be also other health and wellness services all under one roof. Do those organizations, those entities have to be physician owned then, and then they license or share space with the people who are non-physicians?
Yeah, they would have to be physician owned. And yeah, that brings in a good point concerning the medical spas and the type of treatment that they're providing, whether it's medical or it's deemed as medical treatment versus being deemed as non-medical treatment. What's been more popularized and what's becoming something that people are definitely seeking more is non-medical treatment. And that difference has to be made clear. That's more towards things like facials and chemical peelings. But the medical treatment, the more invasive procedures, are definitely the type of treatment that physicians need to be monitoring. So again, I think that goes to the same overview point where we want to make sure that, or the state wants to make sure that a physician is overlooking all of those treatments to keep patients safe.
The key word there is med spa. That word is a broad term that could encompass a lot of different things. So really, when you want to look at it, you got to really understand exactly what services are being provided. If it's Botox, different liposuction, micro needling, things of that nature, more invasive, like Eso mentioned, you're going to fit in that area of physician services, in which case there has to be a physician owned there. But on the other hand, if it's just, certain spa services, pedicure, manicures, obviously that's not in that area of physician services.
Well, we're going to continue our conversation here in Chicago's Legal Latte today, and want to direct you, as always, to lavellelaw.com. Eso and Ted have all contributed various articles there, including this topic and others. Great resource for information about a number of different legal areas. So lavellelaw.com, stop by, and there's plenty of podcasts there to download as well. As we go further into this, another term that comes up is management services organization. Is that, well, I'll let you describe it in terms of what that is and how it factors in.
Yeah, an MSO or management services organization, that's a relationship that can be set up and structured to enable non-physicians to be involved to a limited extent in some of these med spa operations. So if you look at the services they're providing, if it fits in that definition of physician services, so now we know there must be a physician-owned entity providing those services. An MSO is a way to get a non-physician involved. Now you're asking yourself, how do they do that? How is a non-physician involved in that situation? So with an MSO, another entity is created, a management company that would be owned by the non-physician, and that non-physician management company would provide managerial services to the physician-owned med spa. And in return for those services, that management company would receive a fee. So that's the overview of what the MSO would look like with the physician business. And
I'm going to ask a little bit more about that, but I meant earlier to ask, when we talk about things in Illinois, who in Illinois or what entity in Illinois monitors this? Who's responsible that keeps an eye on this and that an owner needs to make sure they're in good standing with?
Yeah, so the IDFPR, that's who you have to have your licenses go through. We've, due to the work that we've already done for clients, we've gotten to make some contacts with them and have a good relationship. So we have a consistent back and forth. This can definitely be a timely process depending on how it's done. But that's where the correspondence is goes back and forth to. They have an online portal in which you can make your applications and make adjustments based on their feedback. Their main office is in Springfield. They have an office in Chicago as well. But the contacts that we talk to are in Springfield.
And in terms of, Ted, what you were mentioning earlier about the Management Services Organization, MSO, once you enter into an agreement or create a structure like that, is there a limit on the services that can be provided, or who does what work, or how the fees are transferred? What is that limit once one is created?
Yeah, first and foremost, the agreement must spell out, what are the responsibilities for the management company, and it must be crystal clear that that management company is not providing these physician services. That's being provided by the physician and the physician's business. And so that must be clear. Because again, though, if you go back the whole crux of the corporate practice of medicine doctrine, they want to make sure that physician services, the judgment of the physician, is not going to be impaired. So the agreement must cover that. And then the hard part often is the fee. What is the appropriate fee for these services? And you mentioned earlier the fee splitting issue. And so what is, it's nothing wrong with paying a fair market fee for these managed services. That's perfectly respected and fine, but how is that fee going to be determined? And a lot of times parties want to try to come up with some sort of percentage-based model. And when you use that percentage, you start bringing in this fee splitting issue that comes into play. Other sort of services, you could have some billing services, accounting services, maybe inventory management services, a whole wide range of managerial services that can be provided by this MSO, but they have to stay away from the physician services. And the one last thing is the fee for these physician services. That fee must be remitted and deposited into an account owned by that physician practice. Now, eventually that money can wind up to the MSO to a certain extent pursuant to that agreement, but initially it has to go into the bank account belonging to that physician practice.
And so maybe my next question is what you just said. So I was going to ask you, if I'm a client or customer at this practice, when I receive a bill, is it from the medical group and I pay them and then they're paying a fee back to the MSO based on their agreement, or would billing come through the MSO? Is that who I would see on my bill when one arrives?
Yeah, I would say that you would be getting a bill from the medical group, and then the management company would get their split. I mean, Ted can correct me if that's not the case, but that's what I
Yeah,
think.
again, it depends on what the fee is for. If the fee is for these physician services, then that fee should be deposited into the bank account owned by the physician practice. Now, perhaps a representative from the MSO can have signatory power on that bank account, and that, again, an MSO representative can then cause a payment to be made to the MSO for those management services. But initially, the fee should go into a bank account owned and controlled by the physician business.
About a minute or so left here. Kind of explain to us then the role Lavelle Law might play in this. Is it in helping set up the corporate structure? Is it doing annual or quarterly filings? Where do you get involved, and how can you help?
Yeah, I mean, we can help in a number of ways. I mean, obviously, if we're help drafting that MSO agreement, as I mentioned before, there's a number of things you want to see that's part of that document. So we can certainly draft that. We would consider the Corporate Practice of Medicine Act, those restrictions when we draft that. In addition, forming the companies, we can form the entity of that management services organization, or also the physician company. As I mentioned, I think it's a wise thing to have an LLC or corporation that is used by the doctors in the provision of these physician services just for a limited liability protection. So we can help with setting up both of those entities.
And so I know you're kind of on the front line of doing this, working with clients. Someone has a question, how do they best get a hold of you?
Yeah, so you can call me directly at 847-705-7129, or you can email me, and it'd be my as in my the first letter of my first name and then my last name at lavellelaw.com, and that's all lowercase. And hope to hear from prospective medical spa owners.
Excellent. Well, I know it's a growing industry, and as always in Illinois, laws change frequently. So best to stay connected and find out that you're on the right side of things. So Ted, Eso, thanks very much for being with us. Time flew as always. So folks, if you have questions, follow up, and then we'll swing back with another edition of Chicago's Legal Latte very soon. Thanks, guys.